I'd like to welcome all of you to the session this afternoon. As you've seen, and as David said, we're talking about eDiscovery this afternoon, and how is it that that has changed the way we all practice law. And at least from my perspective, in a word, the answer to that is clearly dramatically, because I started out practicing about almost 40 years ago, and at that point we had typewriters with carbon paper. So obviously we've seen enormous technological advances that have come along during that period of time, and all of us really as lawyers have had an obligation to keep up with those advances and to make sure that we're at the cutting edge of those. And one of the issues that we see most frequently coming up if you're doing any kind of litigation practice is how do you deal with these very complex and increasingly difficult eDiscovery issues. And unfortunately, I think this is probably going to get more difficult and more complex before it gets better, because as the technologies evolve, and as John will talk about, as those technologies evolve, things are just getting more complicated, and it really is an area that you have to pay attention to, because the consequences for you and for your client can be really significant if you don't. And the panelists will talk about some of the cases that have arisen out of the eDiscovery areas and some of the consequences that we've seen where people haven't paid enough attention to these, or where they violated the eDiscovery rules either at the state or federal court levels. Now, I would refer your attention to the materials that you've been provided for this session. I didn't have anything to do with these, but they are terrific materials, and we'll be talking about most of the issues that are contained in there. But there's a lot of case law citations in there with some of the discussions of the principal cases that we've seen that are probably the most important ones that you ought to be aware of. And even if you're not deeply involved in this issue as a litigator, if you're doing any kind of litigation, I really would encourage you to take a look at those materials, read through them, and if nothing else, sitting through this and hearing about the types of issues that our terrific panel has seen will get you up to speed on a lot of this, and taking a look through those materials will help in that regard. What we're going to do is we're going to first of all try to get us all on an even playing field to make sure we're operating from the same base of information, and that's going to come from John, who, as you know from his session earlier today, is one of the leading experts on eDiscovery and all types of electronic data and security issues. So he's going to talk first about what types of issues he's seen, how that data is created, and things like that. We then are going to hear from our two federal judges, Judge Urbanski and Judge Sargent, who are going to talk about it from their perspective and how the federal rules apply and some of the issues that they're seeing. And finally, we're going to hear from Judge Lowe, who's going to offer his perspective on issues he's seeing at the state court levels and talk a little bit about the types of issues he's seeing. And obviously, if you have questions as we go along, I hope you'll feel free to ask those. The only suggestion would be if you would go to the mic when you do that, because this is being recorded. And finally, we'll try to reserve a little bit of time at the end as follow-up for questions that we might have of each other or that any of you might have from the floor. So with that, let's get us started by having John talk a little bit about what we mean when we talk about electronic data, what are the sources of that data, what he's seeing, how that's created, how it's preserved, and some of the issues he's seeing as a consultant and as an expert on these issues.
Thanks, Tom. Like Tom, when I first started in this business, I'm a lot older than I look, by the way. So I remember typewriters and carbon paper and mimeograph machines and modems that you actually, telephones you put into a cradle, acoustic coupler, things like that. So, but it's really quite different. It's good and bad, and I agree with Tom that it's very, very complicated. I'm sure you folks are totally frightened of all this electronic evidence and electronic information that you potentially have to deal with. But by the same token, there are tools that are also available to you to help you with that, and they're low-cost tools as well. So in a lot of your cases, you're going to be solving small cases. You don't have to do this mega stuff that's out there dealing with it. But I just want to spend a little bit of time kind of getting you to think about electronic information, electronic evidence, and where some of that data might be, and like how you may have to deal with it. I was reading a stat sometime back where a survey where they said that all the information that's created worldwide, approximately 98% of it is born electronically, and most of it's never printed. So, and if you think about that, right, your email messages and all the things that you can consume. Newspapers are going out of business. The actual print, right? We have iPads and we're reading things electronically, ebook readers. So a lot of things are now in electronic form. You're all pretty much, I think, up to speed. You know the computers, tablets, those things. Those contain electronic information. USB drives, external drives, etc. Those have information on them as well. We're not seeing too much of optical discs anymore. The CDs, DVDs, most software now is being delivered either by download or is pre-installed. So as an evidence source, not so much of that. Flash drives are very, very common, especially in business cases. Theft of proprietary data. We see a lot of that. That's because you can get so much on a flash drive and copy stuff so quickly and get it out the door. Smartphones. All right, we talked a little bit about that in this morning's session. A tremendous amount of data that's held on smartphones. Just gobs and gobs of it, and more so. The iPhone in particular is very, very evidence-rich. As far as from an evidentiary perspective, it probably holds, if I had to guess, about 100 times more data than the next type smartphone that's on it. So we do a little happy dance when we get iPhones in our lab. Voicemail systems as well. Right? We remember cassette tapes, right? Tom, it's voicemail systems. They're all hard drive or memory-based now. Or if you're in a corporation and companies, they're hard drive-based. They actually have computers that are storing these things. They're WAV files that they're stored in. So that's evidence as well, potentially. The big thing, probably the biggest area that we're seeing, and if you've been watching the news from the Boston Marathon bombing, video surveillance is the hot thing now. It's so cheap that everyone has it. So what's the first thing the Boston police did, right? They asked people to give them their video from their phones, from the security cameras and things. So a lot of video surveillance evidence now. So now we're not only, so how are you going to search that? That's difficult, right? Now you have to have software that has facial recognition issues, things like that to try to go after that kind of information. It's not as easy as just doing a keyword search on a Word document. So that brings additional challenges too. Backups are another source. Backups are becoming a challenge. I'm sure we're going to hear about Zubeleg in those cases where backup tapes were an issue. Nobody's really backed up to tape anymore. But even if they are, then technologies exist that before, they used to, at least in the Zubeleg case, backup tapes were deemed to be not inaccessible, right? So you had to restore them and do all this other stuff. There's software today that you don't have to restore it. You can read that tape and actually index it and find data that's on there without going through a lot of pain and suffering and cost. So that's another example of, as time has moved on, technology has changed, but technology has also helped, in that regard. Third-party providers as well as data sources. So social media, backups, in the cloud, case management systems, paychecks for payroll or whatever it is. Those are all sources of potential data. So now you've got to get a third party involved. And how are you going to get after that information? So that kind of gives you a lot of ideas of where this information may be. I'm not going to say that every single one of your cases you're going to have to run through all this stuff, but I would challenge you that electronic evidence will exist in every one of your cases. It may not be very important. It may just be you push it off to the side. But it's going to be there, primarily because of email. Everyone is communicating these days via email and doing all kinds of stuff. That and smartphones. Those will be the two big areas. I want to talk a little bit about preserving and capturing and keeping the information. You really have two choices, as I see it, when you're trying to preserve the information and how you go about doing it. You can do what's called a forensic image of the source, whether it's a computer, a flash drive, a cell phone, etc. When you do that, you get an exact duplicate. It's a bit-by-bit copy of that device. And it's validated, so that it is, in fact, a true and accurate image of what the source was. But I'm here to tell you, and that's expensive, somewhat expensive to potentially do that, but I'm here to tell you, you really don't need it all the time. I'm constantly telling attorneys when they come and say, oh, we gotta get this forensic image. Why? What's important? Most of your cases, most of the time, just copying the data is sufficient. Where you're going to need a forensic image is if you have to preserve the system metadata. That's the information about the file creation. When was the file created? When was it accessed? At its current location? Those kinds of things. Then you're going to need a forensic image, because if you copy it, you will alter that data. But if all you're interested in is the contents of particular files, a spreadsheet or those kinds of things, and not necessarily when the actual file was created, but what is contained within it, that metadata is preserved when you copy it. So you can save a lot of money by doing it that way. Some of the things that you're going to run into as you're dealing with these, certainly you're going to capture documents, potentially pictures, that kind of digital media, stuff like that. The challenges are going to be things like databases. So now that you've got this database, how do you go about searching it and getting that information? Whether it's a PeopleSoft database or an Access database or something like that, that now you're going to need to extract the information. In those cases, most of the time what you're going to end up doing is having either a programmer or somebody generate a report that extracts the information out of that database and puts it in a format that you can deal with, that you can then search or that you can then analyze. So you handle databases a little bit differently. I've already talked about the metadata piece of that. Email is a real challenge for you to deal with, especially given the volume, the potential volume of email. And I'm sure you've all seen, the email strings, and it takes 18 different messages just to schedule a half-hour meeting. Oh, I can do this date. No, I can't do that date. Well, if you have copies of all that stuff, it's a lot of data that you're going to potentially have to review and go through. So you want to keep all that stuff down and decide, is the end of the email trail, is that sufficient? And then discard all the other stuff. Because if you can reduce that volume, that electronic information volume, that's less that you have to review, that's less costly, etc., to doing all that. Most email systems today are going to be, I'll call them Microsoft compliant. So you're using Outlook typically to open it, or you have an Exchange server, you're running a PST file, etc. Yes, ma'am?
Yes, good afternoon. I have a question about text messaging on cell phones.
Okay.
What sort of advice you would have for attorneys who are using that as evidence? How to obtain, I see a lot of photos where they're using other cameras.
Yeah, we get a lot of that stuff, and usually they're asking for, if you're looking for deleted text messages, then you're going to need forensics to get that, potentially, and it's going to vary upon the model, make and model of the phone and how long it's been. Certain models don't keep, and you need a physical device to get that the feature phone, the one that just makes the phone call. So that's one thing. The carriers tend not to keep information that long either. So as an example, Verizon keeps text messages for about 14 days, the contents of it for about 14 days. So depending on how far back it is, the carrier's not going to have it. The best shot's going to be on the phone itself. Having said that, if you have a phone that has text messages on it and you can read it, you can still read it on there. I had a friend of mine out in Colorado call me up, and he had this harassment case where I think it was the county attorney or something. Her boss was harassing her via text messages and all this stuff. He says, "John, what would it cost me to, if I FedEx this phone out to you and you make a forensic image of it and do all that?" I said, "Well, why do you need that, David? Can you read the messages?" And he said, "Yeah." Well, heck, you don't need me. If you can read the messages, you've got the evidence. You've got the phone. Just don't delete the darn things. Right? I mean, you've already, quote, preserved it. So it's really, when you end up getting forensics involved, if you're dealing with deleted text messages, primarily. Deleted text messages and deleted photos. Those kinds of things is where you're going to need those kinds of services. But back to the email stuff, if you run across other types of email, GroupWise, Lotus Notes, things that are non-Microsoft based, those can be a real pain in the butt, because there's not a lot of tools that are out there to help you analyze those, and you're going to need potentially the original system to review those. But PST files, when we talk about email, normally I call it it's not a near to, but it's a near. It's not native, it's near native. So when you've heard the term, well, I want these files in native form. Well, if you have a big Exchange database and there's only 3 key players that are involved there, but there's 30 people in the company, you don't want the whole database for all 30 people. That's a ton of data, it's a ton of volume, and most of it's irrelevant. You only want 3. So what you'll do or ask for is that they be produced, or at least that you get them, in a PST file where they use a utility and they just extract the mailbox of those 3 key players. So you get 3 files. That's kind of what you want. Now it's not totally native. I call it near native when you're doing it. It's some modification of it. But that's some of the areas of where this electronic information starts, where some of the challenges you're going to have. Certainly review of the products are going to be, and then I'll stop at that, Tom, and hand it back off. But I want to give you some tools that I think are going to help you and help the solo small practitioner. One product that I think you really need in your toolbox is called QuickView Plus. What QuickView Plus does is it has hundreds and hundreds of file formats, so you can view information, electronic files, where you don't have the actual application. So as an example, if you're doing construction law and there's a lot of CAD drawings that you have to deal with, but you don't want to go out and spend thousands of dollars on AutoCAD to read those files, QuickView Plus will read those. So, and if it's an old version of WordPerfect or whatever it is. So that I think is a really good product for you. And if you're dealing a lot, find yourself dealing a lot with email and trying to figure out how do I deal with conversations and dedupe these things and quickly get to information, there's a product called Proof Finder. It's by Nuix. It's $100 a year. That's cheap. Now it has a limit. I think it's a 5 gig or 10 gig limit that it can process. But that's good enough for a mailbox or a couple of mailboxes typically to do that for $100. 3 other online products that I want to tell you about that where they are actually geared towards small cases and they are very reasonably priced. Usually you buy them like tiers, so you either pay for per gig amount of information, or one of my favorites is a product called Logicull. It's Logickcull, and they do tiered pricing for that. And what's really cool is that you can gain access to it from your iPad and actually do your review and tag it from, all these different things. But Logicull is one, Lexbe, L-E-X-B-E is another product, and then Digital Boardroom. Those 3 products are all geared towards the small case volume.
John, thank you. We appreciate that. That's a great overview, I think, of the issues we're dealing with. Next, I want to turn to Judge Urbanski. And Judge, you've had, I think, a unique perspective from which to view all this. You spent about 20 years as a commercial litigator, obviously dealing with significant discovery issues there. And then you spent about 7 years as a U.S. Magistrate judge, where obviously a lot of these issues were coming before you. And now you're having these cases tried before you. So I was wondering if you could share your thoughts on some of these issues, particularly on preservation issues and where lawyers have run into issues there, and also spoliation and perhaps some admissibility issues as well. Thank you.
Let me say a couple things. I'm going to cut short my presentation a little bit because we started late and we're running short on time. But I want to say this at the outset. I want to thank Dave Harless for inviting me down to Southwestern Virginia to have the opportunity. I want to thank the State Bar and the bench bar folks for the opportunity to come down here and talk to you all about this subject. I came here, I listened to the panel with my friends Wade Massey and Larry Kirksey and Marilyn Tate, and then I was able to listen to the justices, and I got to see some old friends. And since I've been on the district court bench, Judge Wilson and Judge Conrad have been going to Harrisonburg. There hasn't been a sitting district judge in Harrisonburg for 50 years, and they said, as new kid on the block, guess where you're going? And so I've been riding north on Interstate 81. I've got a piece of the Roanoke docket and all of Harrisonburg, so it was really good to turn around and go south. I come back to southwestern Virginia this afternoon. I thank you all for doing that. You know, for many of us who've been around for a while, the prospect of dealing with eDiscovery is just plain depressing. Thinking about it causes me to reflect on how old I am. Do any of you all know where the term Bates numbering comes from? Anybody? Yeah, the Bates numbering machine was a little handheld stamp that you would clap on the table, and it would manually put a number on a document. And I remember in some large litigation antitrust cases actually producing so many documents that we broke the Bates numbering machines. But you know, for some of you younger folks, you may think it has to do with the movie Psycho. But then again, that isn't really right, because for you younger folks, you don't even know who Norman Bates is. But for us, you know, I sat down and I listened to John, and he's talking about stuff that I don't know what he's talking about. He's talking about programs and CADs and this, that, and the other, and you know, I try to stay up to date on these things, but I swear it's hard when you're as old as I am. He was talking about technology, because you know, I know how to use a slide rule. You can talk about a typewriter. I know what a slide rule is. John was talking about technical choices. Well, let's talk about legal choices, and let's talk about legal obligations, and let's talk about what the law, where the law is these days. You know, John mentioned how much data is digital and not taken down. I saw a figure the other day. There's 84 billion business emails sent every day. And in today's, it's mind-boggling. The federal rules, and you know, I listened to the program moderated by Larry Kirksey, and I listened to the second program with the Supreme Court justices, and you know, they were talking about these rules and of the Supreme Court of Virginia. I think I've forgotten what they are because I've been in a different world for the last 9 years. But I'm going to talk a little bit about the federal rules of civil procedure and somewhat about the federal rules of evidence. So if that doesn't, you know, if that doesn't apply to you, then you all can leave. It is Friday afternoon after a while. But in 2006, the federal rules tried to catch up with the emerging eDiscovery issues. And there was changes to Rules 16, 26, 34,
Yes. I get out of my presentation.
Y'all hear me? No. See, this happens to me in court all the time. Man, I got 3 microphones. This is really cool. You know, I feel like Randy Lowe with all these microphones. These rules, they did 5 things to the Federal Rules of Civil Procedure. These rule changes. They broadly define electronic information that's discoverable. They mandate that early attention must be paid to electronic discovery, including the format of production. They limit discovery of electronically stored information to sources that are reasonably accessible. They allow for the, and this is important, they allow for a procedure for asserting a claim of privilege or work product protection after an inadvertent production, and they create a safe harbor under Rule 37 for sanctions for the loss of electronically stored information as a result of the routine operation of computer systems. Now that was the rule changes, and they really haven't been changed since then. That was 7 years ago. It's hard to believe. There have been a number of important eDiscovery decisions I'd like to talk about. I'm going to talk about 2 sets of federal cases, and I'm going to talk about a couple of cases from Virginia that are a little closer to home. The rule changes in technology are important. You know, you would think that eDiscovery only applies to the big case, the securities case, the antitrust case, the class action. But it's just not true anymore. eDiscovery applies to your vendor-vendor case. It applies to your, as Tom can tell you, to your employment case. Because of what? Because of Facebook. Because of social media. Because people are on there. If they were in an auto case and they got a Facebook page, well, you better be looking at that plaintiff to see what he's doing. Because he is putting his life out there. And if you've got a sexual harassment case, it might be helpful to know what the plaintiff is doing. It might be helpful to know what the defendants are doing as well. So this stuff, it applies in each and every case. It is, I think, Twitter, Facebook, all that kind of stuff is a game changer for litigation. Let's talk about the first leading case on the federal side on these issues. Female employee claims she was subjected to gender discrimination, failure to promote, and retaliation. The document request in that case was for emails from 5 of her co-workers. That's it, 5 co-workers. Sounds pretty simple. Inside and outside counsel made efforts to obtain the relevant emails from the handful of employees involved, but some turned up missing. That case, it resulted in 5 published opinions in the Southern District of New York by Judge Scheinman, and the case is Laura Zublake versus UBS Warburg. If you have not read those 5 opinions by Judge Scheinman on those eDiscovery issues, you ought to. It's really easy to find. Zublake, Z-U-B-U-L-A-K-E, Google it, you can find it, all right? I know what Google is, John. When you read, and all the sites are in your materials. I don't want to say the materials done by Belinda Jones and Christian Barton are really outstanding. When you read those opinions, and you look at what outside counsel did in this case, you won't think that what was done was too unreasonable or too slack. But they got sanctioned. And given the sanctions handed down in that employment case, we all need to tread very carefully when you step into the eDiscovery arena. Let's talk about another case decided by Judge Scheinman. It's the Lancer case. It's in the materials, and it's Pension Committee of the University of Montreal versus Bank of America Securities. Now, to be sure, Lancer was a large, complicated securities case involving the liquidation of 2 British Virgin Island hedge funds. But the lessons to be learned from Lancer apply to any sort of case, large or small. What happened in that case was, counsel was retained in the fall of 2003, and they immediately took some steps to preserve evidence. Counsel telephoned and emailed the plaintiffs. This was an issue in Lancer wasn't the plaintiffs failing to preserve evidence. Counsel for the plaintiffs telephoned and emailed the plaintiffs and distributed memorandum instructing the plaintiffs to be over rather than under-inclusive, and noting that the emails and electronic documents should be included in the production. Well, at the end of the day, when 311 documents didn't turn up in the production, Judge Scheinman sanctioned the plaintiffs' lawyers because they didn't do what's called a written litigation hold. And what she was critical of is the emails the lawyers sent did not direct employees to preserve all relevant records, both paper and electronic. And it didn't create a mechanism for collecting the preserved records so that they could be searched. Rather, what she was critical of is the lawyers' hands-off. The lawyer said, I'm going to send you an email, you find the documents, you give it to me. And what Judge Scheinman was critical of in Lancer, this 2010 case, and the sanctions were pretty extreme, was that the lawyers relied on the client to do it. And so what the message from Lancer is, the lawyers need to be involved and have a documented system for what you did to monitor compliance with the litigation hold. She was critical, although counsel sent monthly case status memorandum, they never specifically instructed plaintiff not to record records so they could monitor the production. Let's talk about what lessons come from Lancer. A litigation hold issued, and I'll talk about it a bit more in a moment, needs to be in writing. It needs to emphasize the duty not to destroy. That protects you, that protects your client. Counsel needs to provide written instructions for preservation, search, and collection. What does that mean? That means you got to know about their system. You've got to know the manner in which their computer system, their email and all that is organized. What John was talking about, we've got different email systems out there, Lotus Notes, a Microsoft-based one. You got to know. And as he mentioned this morning in some of his presentations, some of the ethical obligations are requiring knowledge of technology. You need to identify and interview key players whose records need to be searched. You need to be knowledgeable of the computer system. You got to have a hands-on role in the production process and not simply delegate the task to client. You must turn off the routine deletion and overwriting protocols, and you got to document. Now, one of the problems they had in Lancer, and you've seen it and I've seen it, you're in court, you're there on a discovery dispute, or in a criminal case, has all the Brady material been turned over, or in a products case, have all the records relating to the design of this product been produced. And counsel stands up in court and says, yes, they've been produced. We produced it all. Well, you know, you better be doggone sure of that. In Lancer, they went above and beyond, and they got declarations from their clients that all these records were produced. Everything was produced. Somehow or another, 311 documents were located that hadn't been produced, and Judge Scheinel put the hammer down. So one of the problems in Lancer was not only did they not go in and institute a well-documented litigation hold that the lawyers could feel comfortable with, they just ceded it to the client. The other problem was afterwards, they let the client make these declarations that everything was produced when in fact they weren't. And the judge hammered them for those declarations, which the defendants asserted were false and deliberately false. So in other words, stuff happens, okay? Don't compound it by making overly broad statements in court, yes, Your Honor, we produced it all, as to the certainty that all responsive documents have been produced, when in fact they may not have. All right, ethical obligations. John talked about this morning, I'm not going to repeat it. I will repeat one line from a 2006 case out of the Middle District of Florida, in which it was an ERISA case in which the plaintiff was an attorney, and the plaintiff failed to produce some computer documents, claiming he was computer illiterate. The court's opinion says as follows. His claim that he was so computer illiterate that he could not comply with production is frankly ludicrous. Accordingly, he should reimburse the defendant its reasonable expenses, including attorney's fees, for his non-compliance. That's Martin v. Northwestern Mutual Life, 2006 U.S. District Lexus 2866. So you've got ethical obligations that are morphing, and you've got existing obligations as well. When does the duty to preserve arise? Does it arise when suit is filed? Does it arise when a discovery request is issued? No, it arises before both of those. The duty to preserve under the rules, under Zubelag, under Lancer, predates the filing of suit. It's upon anticipation of litigation. In other words, you've got a traffic accident, you've got to start preserving. You've got a disaster at a plant, you've got somebody who gets hurt, you've got somebody who's terminated, you've got to start preserving. Anticipation of litigation. One anticipates, I'm reading from Zubelag 4, all right? One anticipates litigation when a party is placed on notice of a credible probability that one will become involved in litigation, or when a party seriously contemplates initiating litigation, or when a party takes specific actions to commence litigation. And understand how this all gets viewed. This all gets viewed in 20/20 hindsight, with the court sitting up there on the bench and the one side saying, they didn't do it, they didn't do it, they didn't produce it. Gosh, I hope this isn't being videotaped. And the problem is, it's all 20/20 hindsight. And the judge is up there thinking, well, why wasn't it produced? Why wasn't it produced? Why wasn't it produced? You've got to, so when now the law requires, when litigation is anticipated, you've got to start preserving documents. What do? You got to issue something called a litigation hold. It's a written document that says, stop your document destruction policy. It requires you to interview key employees. It requires you to get their documents and monitor the compliance. It even requires you to talk to former employees. Look at Lancer. Lancer is worth looking at. Look at Lancer's in your materials. It's not cited as Lancer, it's pension fund. What are the three components of a litigation hold? You got to identify and preserve relevant information. You got to tell your client, clearly defining what's to be preserved, how to preserve it, what employees have it, and monitor compliance. Do it in writing, protect yourself. Okay, so there's a duty to preserve. And we know when it arises, anticipation of litigation. Do you have to preserve everything? I mean, what's the scope? My company's huge. You know, from a plaintiff, goodness gracious, what's on my wife's Facebook account? Do I have to preserve everything? Look to opinion by Judge Bob Payne out of the Eastern District, DuPont versus Coleman Industries, 803 Fed Sub 2nd, 469. He cites the Zuba Lake opinion and says litigants are not required to preserve every shred of paper, every email or electronic document, and every backup tape. Indeed, such a rule would cripple large corporations. A party that anticipates litigation is under a duty to preserve what it knows or reasonably should know is relevant to the action, is reasonably calculated to lead to the discovery of admissible evidence, and is reasonably likely to be requested during discovery or subject to a pending discovery request. That makes sense. It's the old standard. If it's likely to be discoverable, if it's likely to lead to the discovery of admissible evidence, if it's likely to be relevant, you gotta preserve it and you gotta start out. You know, Zuba Lake and Lancer, when you really look at those, it's hard because those lawyers try, okay? Let me take a couple of examples really quick and talk about some cases that are pretty easy. And I didn't make this stuff up, okay? Taylor versus Miter Corporation, 2012 U.S. District Lexus, 161318. Judge Liam McGrady out of the Eastern District of Virginia decided on November 8, 2012. The plaintiff in this case is a computer expert. He brings a federal lawsuit for violations of FMLA, Family Medical Leave Act, and failure to accommodate his disabilities. After he files his EEOC charge, but before he files suit, he wipes his desktop computer, takes a sledgehammer to it, and sends it to the landfill. All right? After suit was filed, an issue arose regarding his preservation efforts. The court said, okay, you still got a laptop. Let me require you to submit your laptop to a forensic evaluation. After the court order issued, he ran a program on the laptop called, get this, Evidence Eliminator. The court said after all this, there was no way to determine how many files were deleted, and the court dismissed his action as a sanction. You know, applying the four-prong test, the Fourth Circuit under Wilson versus Volkswagen and Silvestri for spoliation and for sanctions. The court said, look, this conduct is so egregious, we're going to dismiss the action, and that's what the court did. Let's take the case out of state court. Again, I'm not making this up. All this comes out of the Supreme Court's published decision earlier this year in Allied Concrete versus Lester, 285 Virginia 295. The facts are pretty egregious. Wrongful death personal injury case by a husband following a wife's death. The claim included mental anguish. The defendant was a concrete company, and they filed a document request. They had gone on Facebook, and they had seen screenshots of the plaintiff, the husband, wearing a t-shirt that said something like, I love hot moms, or something like that, and holding a beer, okay? And the claim is mental anguish. So they want to know how anguished the person is, obviously. And so they get the Facebook, they attach it to the document request, and say, we want the whole Facebook account the day after the document request. Plaintiff's counsel tells his paralegal to clean up the Facebook page because we don't want any blow-ups of this stuff at trial. The paralegal emailed the plaintiff those instructions. Well, the plaintiff went the extra mile. The plaintiff deleted his Facebook page. The next day, after deleting the Facebook page, counsel signed and served a response to the document request stating, as of that day, there was no more Facebook page. Well, you can imagine the firestorm this set off. Allied subpoenaed the emails from the paralegal. Counsel made matters worse by omitting from the privilege log, in response to the subpoena, the emails directing the plaintiff to clean up his Facebook page. At the end of the day, the trial court sanctioned counsel in the amount of $542,000 and sanctioned the plaintiff himself $180,000. Holy cow. All right, those are pretty egregious examples. Let me quit. Those are easier examples. Those are things that nobody ought to be doing. But there are harder questions to be asked. Your client comes to you and says, I've got a personal injury case, or I've got an employment case, and you know that client's probably got some stuff on their Facebook account, probably got some stuff on their social media account, and the client says, well, you know, I've got these pictures of this last party I went to. Can I just delete them? Well, there's no suit filed. There's no discovery request pending. There's no court order telling you to do it. I'm here to tell you that under Zubalay and under the current standard, and under, I believe, your ethical obligations, they can't do that. They can't delete anything. And you would be in a world of hurt as a lawyer if you told your client to do that. Now, let's talk about, Tom asked me to mention admissibility. I'm going to do that very briefly by citing you to a case. Lorraine versus Markle American Insurance Company. Write this down. 241 FRD 534. In fact, I think it's cited in your materials. Magistrate Judge Paul Grimm in Maryland wrote this opinion. He's a district judge now. This opinion is 59 pages long, and it is a treatise. It covers the waterfront on admissibility of all kinds of email, of all kinds of electronic data, from emails to text messages to social networking pages. I mean, it's 59 pages long. It's unbelievable. He has cataloged it. It's like a law review article. It's nice and fat, and it tells you how to do it. It goes through all the federal rules of evidence that apply, Rule 401, whether it's relevant, under 901, whether it's authentic, under 801 and 803, 4 and 7, whether it's hearsay, under 403, whether its probative value outweighs the prejudice, and he talks about the balance and the role of the trial court under Rule 104 in letting it in to start with. It's a great opinion. If you got a question about admissibility of a bit of electronic evidence, just don't listen to me. Paul Grimm's really smart. Read his opinion. Page 13 of the outline. Really a great opinion. Now, one last point I'll quit. The written materials speak of when I read them, they seem to speak of a growing trend in the federal courts towards self-authentication of electronic evidence. And I think we need to tread really carefully here. You know, there is no different federal rule of evidence that applies to this piece of paper versus what's on my cell phone. The same rules apply. The same rules of authentication apply. The same rules of foundation apply. The same rules of admissibility apply. I think we need to tread carefully. A couple of examples. I had a criminal case recently in which the defendant was charged as a felon in possession of a firearm. The charges arose out of some sort of domestic disturbance. In defense of the charge, the defendant sought to introduce a text message, purportedly from the complainant's cell phone to the defendant's girlfriend, stating that the complainant had made it all up and the defendant really didn't have a gun and it was all made up. They had the text message. The government filed a motion to exclude the text message, saying it was a fake. Now, we had a hearing on this issue at which the government established that there are websites that you can go to on the computer that will allow anyone to fake a text message. All you gotta know is the phone number of the person you want to send the fake text message to. You go on the computer, you type in that number, and it makes it look like they're sending it from. You got get your number and the one it's going to, and you can send a fake text message. I had no idea. The government went the extra mile and subpoenaed the actual phone records from the complainant's real cell phone company and found that she had not, in fact, sent that text message. So they demonstrated it was a fake. After the hearing, the defendant pled guilty. Let's take another example from the news this week. Earlier this week, somebody hacked AP's Twitter feed and tweeted that the White House was bombed and President Obama was hurt. Although the AP immediately responded that this was just a hoax, the stock market plummeted. It went down 300 points. Now it came back, but the point here is, in this cyber world, all of us ought to be mindful that the rules of evidence apply to electronic evidence just as to other forms of evidence, and the strictures of authentication are there to keep phony evidence out. I'll stop and let my colleagues talk. Thank you.